Hello there, I'm James Chalungumana, Chief Investigator for Consumer Protection at the Competition and Consumer Protection Commission. Today I want to share with you episode 18 on addressing unfair trading practices. So the law that we enforce is quite wide. We enforce the Competition and Consumer Protection Act number 24 of 2010 as amended by Act number 21 of 2023. So there are various types of unfair trading practices that are identified under this unique piece of legislation. And these identify unfair trading practices across the whole economy. So some of the unfair trading practices that hit consumers the most are issues of defective products. So we have an influx of a lot of, solar products and alternative energy products, which do not at times work the way they are supposed to. And at times, consumers may not be aware of warranty provisions and things like that at the time of purchase. And as such, they find themselves in a situation where there's need for the Commission's intervention as and when they are approached with a situation that requires assistance or redress from a trader. So that's one area that we're currently working with. Also in the financial sector, we have a lot of cases of unsolicited deductions, especially for civil servants. We have a situation where at times it could be because of unscrupulous agents, at times it could be because of not properly securing personal information such as payslips, and we have a lot of cases of unfair trading practices with regards to unsolicited deductions. So this is a case where somebody just finds that a particular company is making deductions on their salary without their consent. Other issues we're dealing with are, of course, day-to-day issues where somebody buys bundles, the bundles are not credited, somebody buys an item which they find is expired, and other such things. So it's important for us to note that the law that we use, that I previously mentioned, is very broad, and as such it looks at cases across the whole economy. So the Commission has various ways in which we monitor these, how we spot them and how we investigate them. So we mainly rely on consumers. Consumers are our eyes on the ground. So when a consumer is faced with an issue, they report or tip off the Commission, who are able to move in and assist with regards to that particular issue. But also of utmost importance is to note that the law that we use allows the Commission to initiate investigations at its own initiative. What that means is that we don't only wait for consumers, we're able to spot things, we're able to look at them, and we're able to institute investigations. Where we have instituted investigations the most is issues of disclaimers. This is a notice where a person or an enterprise is disclaiming liability from a product or service that they offer. So these particular disclaimers take the form of no return, no refund, no exchange. So we're able to take note of these and we're able to institute appropriate investigations, and remedies will be removal of such a disclaimer, developing of a new terms and conditions for refund and returns, and also fining of that particular enterprise. So what must sellers show on labels and price tags, and what happens if they don't? Then display of disclaimers. So it's important to note that as consumers engage with traders, that our law does not expressly require a trader to display prices. But when they display a price, they must not charge a consumer more than the price that is displayed. If two prices are displayed, the consumer must be charged the lower price. So also in terms of products, product labeling law requires that a particular product has the manufacturer's name, their contact details, their address, and also the production and expiry date of that particular product. In terms of disclaimers, like I have mentioned, disclaimers are strict liability under our law, and we are strict, the law rather is strict to ensure that consumers are not exposed to these disclaimers, number one. Number two, there's monetary penalties that are meted on these persons or enterprises that are displaying disclaimers. Also, for the guidance of enterprises, as one of the functions of the Commission, we ensure that we guide these enterprises to display their return and refund policies to ensure that they are fair, and they are also approved by the Commission to ensure this fairness. How does the law block one-sided contract terms, and how is an unfair term determined? So unfair contract terms under the Competition and Consumer Protection Act number 24 of 2010, as amended by Act number 21 of 2023, provide a very unique scenario. Most legal practitioners will argue that once a contract is formed, parties voluntarily enter into it, there's consideration, there's offer and acceptance, then the terms cannot be altered. However, competition law, in this case the law that I've mentioned, provides for altering of terms that seem unfair or removing of the whole contract as a whole where it is seen that it causes a significant imbalance to the rights of a consumer, to the detriment of that particular consumer. So what that means is that when a contract term is assessed, or a contract itself is assessed, it is assessed for unfair terms in that contract, and that contract will only be enforceable if the unfair term is removed. If the whole contract is unfair, then it means that the whole contract can be cancelled, and the terms have to be relooked to ensure that they are not detriment to the rights of a consumer under that particular contract. So that's a particular clause that ensures that we correct the market to ensure that there are no unfair terms that are to the detriment of the consumer. So this is common in labor agreements, for example, in retail trade, where labor terms are favoring enterprises rather than the consumer. So at times you find that when we assess those particular terms, we look at case law, we look at contract law itself, and we assess it for having unfair terms. When we identify the unfair terms, we will have the unfair terms removed from that particular contract, and apart from having the unfair terms removed, we will ensure that remedies are provided going forward, meaning that particular contract or the terms are going to be revised to the benefit of creating a level playing field to the parties, to the benefit of both parties. So what constitutes false or misleading representations, and how do they affect consumers? So false or misleading representations provide scenarios where consumers are not told maybe the history of a particular good or how a particular feature of a product works. For example, a warranty provision, whether a particular good is brand new. And also, you remember I mentioned unsolicited deductions. There's the aspect of consumers, especially civil servants, facing unsolicited deductions on their payroll. That also constitutes misleading representations, because a particular person or enterprise is misrepresenting that a particular consumer agreed to acquire certain goods or services. So these affect consumers in the sense that it distorts their purchasing decision. So consumers enter into a particular contract for the acquisition of goods or services expecting certain benefits. So for instance, if you buy a phone and you're told it's brand new, yet it's refurbished, then that's a false misrepresentation. The other example, of course, I gave was unsolicited deductions at payroll and other such types of misrepresentation. So when the Commission investigates such cases, the remedies involve, of course, a remedy to the complainant. It could be a replacement, it could be a refund, it could be a repair. But also another remedy, which is a deterrent, is the meting of a financial penalty on that particular person or enterprise in the forms of either penalty units or a percentage of their annual turnover respectively. So what qualifies as defective or unsuitable goods? So in terms of defective goods, we talk about goods that are either defective, number one. Number two, they are not fit for purpose. Number three, they are not in accordance with what a particular consumer mentioned to the particular person or enterprise. So here we look at everyday goods. It could be equipment, it could be cell phones, it could be solar products, it could be cell phones and other such things. So defective products have a certain way in which they do not perform how they are supposed to perform. So if a particular product is defective, it will not perform to a particular standard that it's supposed to meet. So for instance, a cell phone will not have a battery that's as long as it's supposed to last. A solar battery will go off in 30 minutes or 1 hour instead of a number of hours. Or you mention to a particular trader that you'd like to use a particular product in a certain way, and they assure you that it's going to perform that function, and yet it falls short of meeting that expectation. So consumers are affected in the sense that they do not get the utility they are supposed to. Apart from the utility, they may be exposed to dangers. As you may be aware, unsuitable or defective products may have certain attributes. For example, there could be sparks, there could be a fire, and there could be any such hazards that arise from a particular defective product. And as such, consumers are affected and exposed to such. So the Commission does not take kindly to such. For defective and unsuitable products, the first point of redress for a consumer is a full refund. A replacement will only be if a consumer has chosen to obtain a replacement. But when it's determined that a particular product is defective, through our expert assessment, which is another initiative the Commission uses, we have expert engineers that assess these products at the Commission's cost to ensure that we determine impartially and objectively whether a particular product is defective or not. So only after that is when we determine, and when that determination is done, the Commission also reserves its right, apart from a replacement, which is the second point of redress, if practical and if a consumer chooses, and a refund, which is the first point of redress. The Commission can also send such a person or enterprise to the courts of law, and upon conviction they will be required to pay a certain fee or certain penalty in order for them to ensure that they are not engaging in such defective products to consumers. So what constitutes an unconscionable conduct in consumer transactions? So unconscionable conduct in the Competition and Consumer Protection Act amendment that was done in 2023 was an introduction that identified that certain conduct is harsh and it defies normal logic in the way certain persons or enterprises engage with consumers. So you find that when there's a shortage, for instance, or in emergency times, certain enterprises will tend to increase prices of particular products unreasonably, or they will go on to treat a particular consumer in a way that defies normal business order. So this is an exciting inclusion in the consumer protection law, and as such, it is used to ensure that traders do not unfairly or unconscionably treat consumers. In product labeling, are there any disclaimers ever allowed by the Act? So when products are being labeled for sale or exposure to consumers, disclaimers are not allowed. So like I previously mentioned, disclaimers usually take the form of a no refund, no return, no exchange notice. And these are meant to disclaim any liability or any rights that a consumer might have under the Competition Act and under any other written law. So these are not allowed. These are frowned upon as strict liability, and both persons and enterprises can be charged penalty units, and a percentage of their annual turnover respectively. So this is among other remedies, such as removal of a disclaimer, rewriting the terms of a refund or a replacement, and other things like that. So the law is very strict on disclaimers, and it does not in any circumstances allow the display of these disclaimers. The reason is very simple. You might have a genuine complaint as a consumer, and you will fail to go ahead to approach a particular trader just because they have put a particular notice saying once goods are bought, no return, no refund, and no exchange. How can consumers get refunds or damages when goods are defective or conduct is unfair? So the Commission has various provisions that it uses when investigations are conducted. I spoke about expert assessment in the case of defective products. An investigative report will be provided to the technical committee, then the Board of Commissioners, with recommendations at secretariat level, explaining, according to the provisions of the Act, the remedies available to consumers. So, for example, in a defective product case, there will be a refund. So that's a remedy directly to a consumer. That money is refunded straight to a consumer. There will also be maybe, for instance, the ensuring that this particular trader does not trade in defective items again. So this could also include inspections at their trading place to ensure that they do not stock those defective items. If need be, a product recall is also an option, where a product as a remedy, where a particular product is recalled from the market as a directive from the board, and if such a product reappears on the market, then there's further punishment that is due to a particular trader or person. So in terms of damages, the law does not allow the Commission to determine damages, so we do use our investigative reports and give them to the particular affected consumer after they obtain these remedies for them to use in the courts of law in order to obtain further redress from there, because there may be certain determinations that might need to be made that the Commission is not competent to make. So I'd like to urge consumers out there that the law has various aspects or provisions on unfair trading practices. The law that we use, the Competition and Consumer Protection Act number 24 of 2010, as amended by Act number 21 of 2023, has an economy-wide coverage, and consumers are urged to come forward whenever they are affected or faced with any types of unfair trading practices. This is James Chalungumana, Chief Investigator for Consumer Protection, and we look forward to serving you.